Welcome to Part 1 of the FIPPA Awareness presentation on role, scope, and key definitions. The FIPPA Awareness presentation has been broken down into 5 parts that together are intended to help employees of public bodies feel more comfortable with how the Freedom of Information and Protection of Privacy Act, or FIPPA, affects their work. The other 4 parts of the FIPPA Awareness presentation are Part 2, Access to Information, Part 3, Protection of Privacy, Part 4, Oversight and Accountability, and Part 5, Things to Think About. During this first part of the FIPPA Awareness presentation on role, scope, and key definitions, we'll discuss the roles required under FIPPA, FIPPA's parts and purposes, the organization's records and information that fall under FIPPA, and some key definitions that will be helpful in this and other parts of this FIPPA Awareness presentation. I will begin this discussion on role, scope, and key definitions by telling you about the role this office serves. The Information and Privacy Policy Secretariat is an office that supports the minister charged with the administration of the Freedom of Information and Protection of Privacy Act. In that regard, the Information and Privacy Policy Secretariat assists public bodies with administering FIPPA, provides educational services in relation to FIPPA, prepares an annual report that is tabled in the legislature by the minister, and offers a help desk service both to the public and to public bodies. Now for the roles that are required and can be delegated under FIPPA. FIPPA requires that there be a head of a public body who is ultimately responsible for all decisions and actions under the Act. The head must make all decisions respecting access and ensure that all the personal information in their public body's possession is being properly handled and protected. For government departments, the head is the minister. For government agencies, the head will depend on if the agency is incorporated or unincorporated. If incorporated, the head is the person who serves as the chief executive officer. If unincorporated, the head is the minister who is charged by the Lieutenant Governor and Council with the administration of the act under which the agency is established. And finally, for local public bodies, the head is established by way of resolution or bylaw. FIPPA allows for any duty or power of the head to be delegated to any person. FIPPA refers to those individuals as access and privacy officers. The ability to delegate responsibilities helps public bodies to effectively administer the requirements under FIPPA, particularly in larger public bodies. FIPPA requires that every public body appoints an access and privacy coordinator who looks after the day-to-day administration of the Act. This will usually involve coordinating the process for responding to access requests, maintaining statistics, reporting them to our office, and assisting with any privacy considerations within the public body. Depending on the structure and size of your public body, there may be several access and privacy officers, or the officer and coordinator may be the same person. Typically, there is only one coordinator. That role can be a full-time job or just one of an employee's many responsibilities, again, depending on the size and structure of the public body. If you have FIPPA-related questions, it's always best to start with the Access and Privacy Officer or Coordinator within your public body. If you're not sure who your public body's FIPPA contact is, our website does contain this information for most public bodies. Now to explain what FIPPA is. FIPPA is an acronym for the Freedom of Information and Protection of Privacy Act. As its title suggests, FIPPA provides the legislative framework for the information and privacy rights in Manitoba government departments, agencies, and local public bodies. The law itself consists of 8 parts and 1 regulation. This FIPPA awareness presentation focuses mainly on parts 2 and 3 because they represent the 2 main purposes of FIPPA. The first purpose is to provide the public's right of access to records in the custody or under the control of public bodies, whether they contain personal information or general information. This includes the right of individuals to have access to their own personal information held by these public bodies. This right contributes to meaningful participation in the democratic process by keeping government and other public bodies accountable. Access is subject to limited and specific exceptions. The second purpose is to ensure public bodies protect personal information. Public bodies require personal information in order to deliver services and administer programs. FIPPA lays out the ground rules surrounding the collection, use, and disclosure of that personal information. The rules ensure that individuals have control or an understanding of what is happening with their own personal information. The differences between these two parts of FIPPA is further discussed in the protection of privacy part of this FIPPA awareness presentation. Let's discuss the scope of FIPPA. Section 4 of FIPPA states that it applies to all records in the custody or under the control of a public body. However, the provision goes on to describe certain types of records that are not included, such as court records or constituency records of elected officials. Essentially, of the three arms of government, the executive, legislative, and judicial arms, FIPPA is only intended to apply to those records of the executive arm. To help us better understand the application of FIPPA, I'll explain what is meant by the terms records, custody, under the control, and public body. First, we'll talk about custody and under the control. Custody typically refers to records that are in your organization's possession. This can include records that you create, records that are created for you, or records that were provided to you for any reason by anyone. Under the control typically refers to records that your organization is responsible for protecting, managing, or making decisions about. Examples of when records can be under your organization's control but not in your custody is when the records are off-site for long-term storage or permanent preservation, or when they are being managed by a third-party service provider that is providing services on your public body's behalf, likely under an agreement or contract. Now to explain the term public body. FIPPA applies to public bodies, which is a defined term in the Act. The offices and organizations listed under the definition of public body include, but are not limited to, those that appear on this slide. Government departments are departments, branches, or offices of the executive government of the province. Government agencies consist of two types: those bodies in which the members of the governing board are appointed by the Lieutenant Governor in Council or an act, or those that are specifically designated as a government agency in the FIPPA regulation. Local public bodies are broken down into three types: local government bodies, educational bodies, and healthcare bodies. It's helpful to note that a public body under FIPPA is also a trustee under the Personal Health Information Act, because the definition of a trustee under that act includes public bodies. The Personal Health Information Act, or FHIA, is considered companion or sister legislation to FIPPA because it's based on the same fair information practice principles. FHIA is not discussed in this presentation because that act is administered by Manitoba Health. But it should be noted that all public bodies handle personal health information at some level, even if it's just that of your employees, sick notes for example. That type of information must be handled, secured, and otherwise protected in compliance with FHIA, not FIPPA. Due to the level of sensitivity of personal health information, FHIA is more prescriptive than FIPPA, calling for more heightened protection and security requirements. The term record, as defined in FIPPA, refers to any information in recorded form. The definition goes on to describe the various types of mediums in which the information can exist, such as written, photographed, and stored in any manner. This slide provides some examples of records. Some are quite obvious, such as letters or invoices. Others may surprise you, as you might not think of them as records that could be requested under FIPPA, such as maps, sticky notes, instant messages, or calendars. Please note that these are examples of records as the term is defined in FIPPA. As discussed in the Access to Information part of this FIPPA awareness presentation, FIPPA provides direction to public bodies on making decisions to request for access to records. However, FIPPA does not dictate how long records should be retained by a public body. The length of time records are retained is a policy decision that must be made by each individual public body. Some public bodies, such as government departments, must comply with the Archives and Record-Keeping Act that requires retention policies for all records. Sometimes this office is asked whether or not a record is FIPPable. For example, are briefing notes FIPPable? I'm often not clear on what the person means by FIPPable. If they are asking if those records fall under FIPPA, The answer would be yes, because they are in the custody or under the control of their public body, and they fall under the definition of a record. Therefore, they can be requested under FIPPA. If, however, they are asking if they can be disclosed in response to an access request under FIPPA, the answer could be yes or no. An analysis on the content of the record must be done to answer this question. What this analysis entails is covered in the Access to Information part of the FIPPA awareness presentation. It is also important to mention that FIPPA defines the terms personal information and personal health information because the content of some records can consist of personal information and personal health information. FIPPA contains some specific access decision considerations and protection of privacy requirements for personal information. FIPPA defines personal information as recorded information about an identifiable individual. The definition also includes a non-exhaustive list of personal information types. The following slide contains some examples. It's likely obvious how some of the examples listed fit within the definition of personal information because you can identify a specific individual with it. This includes information like name, address, or phone number. Others may not be so obvious. Depending on the context and the combination of some of these personal information types, you would not necessarily need a name to be able to identify an individual. For example, if employment, gender, and opinion was contained in a document, someone may be able to identify the individual that the personal information is about based solely on that information, especially if the situation described in the document is very specific. A quick note about opinions. There are two different aspects to opinions. If I have an opinion about something, then that is my personal information. But if my opinion is about another person, then that opinion is the personal information of that person. You'll also notice that personal health information is listed here. That's because, like all others listed on this slide, personal health information is one type of personal information. Speaking of personal health information, this term is also defined in FIPPA, and it's identical to the definition that appears in FEA. This slide summarizes the definition. For the full definition, you must refer to either FIPPA or FEA. For more information about FIPPA, there are several resources that can assist you. Our office has a FIPPA website that contains further information to help you to understand and administer FIPPA, such as the legislation itself, questions and answers, and instructions about how to make a request for access to a public body or how to make a complaint to the Manitoba Ombudsman. Of particular assistance is the FIPPA Resource Manual that essentially explains each provision in the main parts of FIPPA. The Manitoba Ombudsman's website also contains valuable guidance material, such as investigation reports and practice notes on a variety of FIPPA and FEA-related topics. And of course, legal counsel is an important resource. While the Information and Privacy Policy Secretariat may be able to assist you with factors and relevant portions of FIPPA to consider to help you make your own decisions, legal counsel can provide you with direct legal advice. And for those with government departments, the Government Records Office on the Manitoba Government's intranet site has guiding information related to managing records, including an introductory course that is offered through organization and staff development. If you are not with a government department, you can check with your own public body's records manager or officer for applicable policies, procedures, or guidelines. Thank you for your interest in the FIPPA awareness presentation. With this information on the roles, scope, and key definitions, you will better understand the other parts of the presentation. Please consider listening to the other parts of the presentation for more valuable information that will assist you with carrying out your responsibilities in compliance with FIPPA. If you have any questions or comments, please feel free to contact us at the Information and Privacy Policy Secretariat.